Well, thank you everybody for joining me today. I look forward to talking a little bit about estate planning and what that means here in the state of Arizona. And wanted to get started real quick with two things. I wouldn't be a good lawyer if I didn't do a quick disclaimer. That is, this doesn't itself create an attorney-client relationship, but I appreciate you watching it. I do encourage that you meet with somebody you feel comfortable with. I do hope this is kind of giving you a high level overview, but it's important to work with an attorney to make sure all of the details and elements are in place and to establish a formal relationship of that nature. A little bit about myself. My name is Emily Taylor. I've been licensed to practice law in the state of Arizona since 2007. I feel very fortunate that the firm is celebrating its 11th year. We are located in Phoenix, Arizona, but we're able to work with clients throughout the state. You can see a few of our team members in the picture on the screen here. But I grew up in the Midwest, came here to go to school, and have stayed ever since. ASU and U of A are both covered, and I apologize, but if I go back to school, I'll go to NAU next time. I feel very fortunate that our practice is able to work with a lot of clients. One of the things we spend a lot of time working on with families is special needs planning, so that's a part of our practice. But wills, trusts, and the like are a big part of what we do, and there's a lot of wonderful organizations that I'm a part of. But enough about me. We're here to talk a little bit about estate planning. I did want to start on our website. We do have a estate planning workbook that I think is really helpful to get started thinking about all the different things that you're considering as we work on your plan. It's free for download, and so you get a PDF. I encourage you to print it out. If you really want us to mail you one, we're happy to print it out for you and bind it up and mail it out. But you can find that there through that QR code or by finding our website, emilytaylorlaw.com. And within that, on the drop down is a digital resource page. The reason I encourage that is because a lot of what, at the end of the day, we're talking about our legal tools, and we're going to get into that. One of the first things we always need to be considering when we're trying to answer, what is it that I need? Do I need a will? Do I need a trust? What the heck? And it's not a one size fits all. Estate planning is and should be very personal. And when it comes down to it, we really need to be clear about what our goals and our concerns and what we're trying to accomplish is. And so within that workbook, but here also on the screen, you can see kind of any number of things that come up for folks when thinking about this. Of course, making sure we've got the right people in place that they can do their job. But you can see on the list, some people are worried more about taxes and minimizing taxes. Some people are worried about their pets. Some people have a child with a disability or just want to make sure everything's nice and easy, or you went through an experience yourself and it was messy and stressful and you want to prevent that for those who might have to handle your estate. So all sorts of different things, but I think it's worth taking a moment to think through your life, your circumstances, and your goals and concerns, because that's going to help us formulate a plan that's personal to you. Um, and so work on that, think about it. But today, our goal is to talk about estate planning at a high level. And, the first question is, what exactly is an estate plan? A lot of us think about binders full of paperwork. Maybe your parents or another relative showed you their trust or their estate plan, and it was a book they took off the shelf that dusted off, and it was just a lot of legalese on some paper. And on one hand, that's an accurate definition, but on another, I think what I like to remind folks is that what an estate plan really is a series of decisions about putting the right tools in place and having the right team behind those tools. Because at the end of the day, a lot of people have similar goals. That is, I want to make sure that if I can't make or communicate my own wishes while I'm alive, whether that's in health or finance, that I've got the right team to do that. I want to make sure that at death, the right person is stepping in to handle my estate to make sure everything gets to where it's supposed to go. And I want to make sure I do that in a way that's protective for the people I'm leaving assets behind for. And hopefully, most of the time, people want to stay out of court as best we can. So, usually, what an estate plan is the tools we need to accomplish those goals based on what you have. And so it's really critical that we broaden kind of our definition of what an estate plan is into thinking through how can we accomplish those goals plus our personal goals and concerns we've shared. First and foremost, one of the places I like to start is with our healthcare documents. These tools, these advanced directives, are tools that are going to allow for the right team to communicate and make our healthcare decisions when we can't do so ourselves. So it could be a short-term situation where we're under anesthesia. It could be a long-term situation where perhaps we have a cognitive disability or inability to make decisions due to dementia or Alzheimer's or injury. But the reality is that for most of us, at some point, we're going to need these documents. So from the day we turn 18 until the day we're in the ground, one way or another, healthcare directives are really critical to making sure we've made it easy for the right people to make these decisions and to communicate our wishes. So commonly in Arizona, you'll see a series of documents. The first and frankly, maybe the most important in this group, but I shouldn't say that, they're all important, is our healthcare power of attorney. So our healthcare power of attorney is going to spell out who is our team. Sometimes we'll find that we have a spouse that's first and foremost in line. Sometimes it's a parent, sometimes it's an adult child. Sometimes we've got a whole slew of folks that are appropriate to make this, and we're going to put them in order. Occasionally, we can have a team of people. And for some people, that means we're going to look to a professional, a fiduciary, to make these decisions. So we get personal and creative, and that's a critical part of thinking about who would be a good advocate for you in a healthcare setting. We know that going to the hospital, having a pharmacist and a doctor and specialists and all of these different organizations, we need somebody who can keep all that information. We also need somebody who can understand what our personal values and philosophies are. And that's going to be part of what we communicate through a living will. So often you'll see a healthcare power of attorney and a living will, not a last will, but a living will go hand in hand. The healthcare defines the team. The living will is going to define more of what the choices are we want them to make. The healthcare power of attorney in Arizona is also going to be where we make 3 critical decisions related to shortly after we've passed away. Number 1, do we consent or not consent to a voluntary autopsy? Kind of strange, but some people have very strong beliefs about that. And so we want to be clear that we've authorized it or not, or we just said, hey, our team can decide. We're also going to communicate our wishes regarding organ donation. Sometimes it's as simple as no, I don't want to be a donor. Sometimes it's broad that we want to be a donor, and sometimes it's specific to a research program, to transplant or therapeutic only. We get to be really personal. And then the third decision that we're going to communicate through our healthcare power of attorney is what do we want done with our remains? So our 2 big options we see commonly are burial and cremation, but it's changing. There's a lot of different options. Arizona's recently authorized aquamation or water cremation, as well as composting or soil cremation. So we have new and changing opportunity to express what our wishes are. And so sometimes we might say, this is very clearly what I want. I want to be buried in this plot at this place. Sometimes it's a matter of, I want whatever's most environmentally friendly at the time. Or I want to be cremated and this is what I want with my ashes. So something to think about, but that's what we're going to communicate in our healthcare power of attorney. Our living will then again, like I said, kind of buffers that or maybe that's not the right word, but dovetails with that by saying, here's how to make tough decisions for me. Here's what I define as an acceptable quality of life. Here's what I want in terms of treatment or decisions to be made if I have an Alzheimer's or dementia, feeding tubes, that kind of thing. So that's really critical. Now you'll see on the screen in between that, we've also got a mental health care power of attorney. That's somewhat unique to Arizona, but it's the idea that we have a separate document related to our team for making mental health care decisions, and primarily whether or not we authorize inpatient psychiatric care. And so it's our practice in our office to prepare this for everyone, and most people sign it. And that is because even if you've not had a mental health care crisis or not needed that level of treatment during your lifetime, it doesn't mean it's not going to happen in the future. We want to make sure that if we've got a team or of appropriate people, that they can make those decisions, again, without having to go to court. And then you'll also see HIPAA everywhere throughout, making sure the right people can get the information they need to make the decisions that match our intentions. So we'll have a HIPAA waiver that allows for that. And then the last piece here is what we commonly hear of as a DNR, a do not resuscitate order, and a POST, which is a little different. That's a physician's order for life-sustaining treatment. Those two documents are instructive or in controlling for our hospital and our first responder teams. So DNRs and POST typically don't get signed in our office. You need to be counseled by your medical provider, but they fit in this part of the planning, and so it's critical to have. So again, not a lot of limelight, no movies. Although some TV shows have done a good job recently of bringing up these in critical documents, but I think this is a great place to start. There's also a pretty low threshold to get these in place. Arizona does have free health directives that we've described here, and you can find them through our Attorney General's website. They're not perfect, but they're a wonderful place to start, and they're really easy to implement. Now, all of these tools, we can start to see where we're defining our toolbox, are going to help make sure that we don't ever have to go to court for a guardianship. Because if we're critically injured or ill and we're unable to make these decisions ourselves, our hospitals, our doctors, our treatment teams are going to be looking for this paperwork. And if it's not there, that's when our family or our friends look to the court to have the court step in to appoint a guardian to make these decisions if we haven't done that so far. So really critical there to make sure that's in place. Now, similarly, we're going to need a tool that's going to allow for somebody to make our financial decisions if we're still alive, but for some reason we can't do it ourselves. Commonly, we're going to think about a durable financial power of attorney. Now, the terminology can vary. It could be a general power of attorney, a property power of attorney. You see different terminology from different states and different locations and different forms, but the idea is the same. We're communicating that our decision making as it relates to finance, if we're alive, is either one of two things. It's effective immediately. I sign a power of attorney that says, upon signature, then I grant my spouse the ability to make my financial decisions from this day forward, even if I'm incapacitated. Or it might be what we call springing. I might sign a power of attorney that says, effective only upon a determination of incapacity by my physician, may this person or this professional or this team make these decisions for me. But this is really important because most of us have a period of time, either towards the end of life or again during an emergency, where we can't make or communicate our financial decisions. And that can require a court intervention called a conservatorship. And so again, we hear a lot about probate and how much we want to avoid probate, but I will also say that guardianship and conservatorship avoidance is critical as well. And we do that through making our plan include our healthcare directives and our financial power of attorney. Now, some other tools that people will use, and we need to understand how they interplay with our tools, are decisions directly at our financial institutions. So sometimes our financial advisors or our bankers, or we might just go in ourselves and say, I want to add somebody as a co-owner or a signer. Those are two very different things, and we need to be careful about what we do in that case, because what we think of as a simple decision, because, hey, I want my daughter to be able to help me pay bills, can lead to a big disruption in our estate plan, because co-ownership is going to supersede beneficiaries. Co-ownership is going to supersede our wills, our trusts, and all of the things we're going to talk about today. So very important that we understand that that power of attorney is critical. It's going to be part of the set of tools we're going to need to make sure that financial matters are handled by the right people at the right time with the right authority and hopefully staying out of court. But we've got to understand that we need to be super cautious as it relates to co-ownership of accounts and signers on accounts. Now, as we transition into the main point of discussion, do I need a will? Do I need a trust? What kind of plan do I need at that point? I want to come back and ground us to the very first thing that's really critical to me. And that is that no matter what our legal tools say, our wills, our trusts, etc., we have to understand that ownership and beneficiary designations will control and will supersede our wishes put in these legal documents. So I always believe, and we ask our clients to help put together a list or a spreadsheet, or, we'll ask nosy questions, but let's understand what really is a part of your estate. And that's different for everybody. Some people might have, bank accounts, checking, savings, CDs. Some people might have a lot of property, vehicles, personal artwork, jewelry, all these different things. We talk about investments, retirement accounts. Everybody's got a different setup. And regardless of how much is in those accounts, everybody has an estate, big or small, it doesn't matter. But the first layer of understanding our estate plan is understanding what we have, what the title of ownership is and how that controls, and whether or not we have beneficiaries listed. And again, I can't overemphasize how important it is to understand this, because that ownership, if we've got joint tenancy with right of survivorship on a bank account or on a piece of property, will mean that that survivor owner is going to own that asset. If we've got a will that says something else, that's not going to matter in that case. So I always emphasize that the first step of understanding what we later want to do through a will or a trust or some combination of these different documents is really have put together a consolidated, accurate snapshot of what there is today, how it's owned, what beneficiaries look like, so that we can make sure that that ownership and those beneficiary designations are going to be a part of our plan and going to be consistent so that our wishes are followed. So if we start with wills, most of us, have heard all of the Sherlock Holmes, story of a will. We've maybe seen somebody jot something down on a piece of paper in the movies. We've seen or know maybe our parents went and set up a will. Maybe you did that. Sometimes people will download a will off the internet. But wills are critical because they do allow us to think through and make some very important decisions. Primarily, a will is going to be where we're going to nominate a personal representative. So personal representative is the term we use in Arizona, but it's an executor, right? It's who we think of as stepping in when we die to gather our assets, pay our bills, find our beneficiaries, divvy everything up. And so in our will, we're going to nominate a personal representative. Wills are also where we're going to nominate a guardian. And this is important if we have minor children or if we're somebody's guardian as an adult. So if we have incapacitated adult children or other people that we're guardians for, we're going to nominate a successor guardian in our last will and testament. So we're going to have that piece in place. Now, wills also are going to be where we can spell out where we want our assets to go. Now, it's intentional that I said here on this slide that it directs the distribution of estate assets. Because if we go back one slide, we have to understand that ownership with rights of survivorship or joint ownership doesn't necessarily mean that that asset will become a part of our estate. Same with beneficiary designations. If my retirement account says when I pass away, my spouse is the beneficiary, that is not going to become a part of my estate because that beneficiary designation is going to be a non-probate transfer. My spouse will have to provide a death certificate and fill out some paperwork and work with the financial institution, but there's no point in which that asset doesn't belong to me or them as long as that can be demonstrated. So it's not an estate asset. So what does a will control? A will is going to control those assets that by nature of ownership and beneficiary designation, the only owner of our interest in a property or our interest in an account is ourselves. And there was no named beneficiary designation. So you can see how critical it is to make sure we really understand how our assets are, because a lot of people think, oh, if I write a will, that's going to control everything. But in fact, those contract obligations of having beneficiary designations or co-ownership with rights of survivorship mean that that asset is not going to pass as part of our estate. Now, the other piece of language that I was intentional on using in this document is nominate. Nominate a personal representative does not mean we appoint a personal representative. The only party that can appoint a personal representative is the court. And in fact, that's what probate is. Probate is the process of appointing a party, if we have a will, who we've nominated. If we don't have a will, then a person on a statutory list of priority. But the probate process is first validating a will if there is one, making a finding of intestacy if there isn't one, and then the appointment and supervision of our personal representative. So having a will does not avoid probate. And that's a myth or something that people believe, is that if I've done a will, I don't have probate. And that's just not the case. If we have estate assets, then we have probate. That's probably going to be necessary. Having a will is still great because it still allowed us to decide critically who we want to do this job and where everything should go and our guardians. But it doesn't mean we avoid that critical step of the court having to get involved to appoint a personal representative. Now, in Arizona, there are a lot of different types of probate, but there's kind of four primary ones. The first one is a formal probate of intestacy. There was no will, and for some reason we need to go to court and we need to have a hearing in front of a judge. Usually because maybe people are disagreeing or there's no clear line of succession on who should be the personal representative, but there's formal without a will. There's also formal with a will. Maybe there's something got missed on the will. Maybe we can't find somebody to act. But both of the formal types of probate require a hearing in front of a judge, publication of notice, all sorts of steps. We also have two informal types of probate, and that is informal without a will and informal with a will, as you might imagine. So you can see where the probate gets complicated. Now, probate gets a bad rap because a lot of people, their experience with probate is negative because it's slow, it's expensive, it opens doors for people to step in. That's not always the case. Probate's not the end of the world in some instances, but it's still got some downsides. So that idea of what probate is again the appointment of that personal representative and then a series of processes that that personal representative is going to have to follow and the supervision of the court making sure that those things are accomplished and done. So, what are the negatives of probate when we look at it? Now, time consuming. Probate can take a while. One of the requirements of a probate is that we publish notice to our creditors. So we publish in a paper that creditors read that you've passed away and they have a set time period. Now in Arizona, that's a 4-month time period, but that's kind of in the middle of administration. So we want to go back and say, what can we look at for a timeline? Well, it's no less than 4 months, but there's going to be a time before then to get everything lined up, to get the paperwork to the court, to get the death certificate. Then there's going to be the probate period for notice to creditors, and then there's going to be ongoing administration as well. So we don't really know how long it can take, but it's slow. It can be costly. Probate is difficult to make sure we've got in place all of the different legal elements of the filing. And so the paperwork's there. You can look for it in the county website for the court, but a lot of people usually need to hire a lawyer to help them through the process. And so it gets expensive pretty fast. It's also public, so the public can get access to the records of probate. And so it's important if we want any privacy that we, again, hopefully avoid that. And it also gives up a lot of control. And that's because during the probate process, we have to follow the court's rules. We haven't made all the rules. We don't even know what all the rules are. We just have to follow them. So we lose some control. And if there's a judge having to make a decision, their discretion and decision making is going to be important. They're going to follow the law, but they've got to understand. And then again, potential for family conflict. Now, I will say there's always potential for family conflict. However, when we look at setting up a probate, one of the things that's required is that if a probate is opened, certain people must be notified. So for example, if I wrote my will and I said I have 3 children, but I'm estranged from one of them and I do not want to provide for them, that's fine. That's fair. I can make that decision. However, if that will has to go to probate, part of the probate process is that my natural heirs are going to need to be notified. So the child's going to learn that they're not included and they're going to see a copy of the will. They also can potentially see what the inventory of my estate is, all sorts of things. And so it opens the door and invites something. So how can we avoid probate? And coincidentally, somebody just asked this question live. Number one is joint tenancy sometimes. So we got to make sure our joint tenancy of ownership is with rights of survivorship or a different mechanics depending on where you're at and what that looks like. But sometimes that can avoid probate. That also opens risk. So people will say, should I give my house to my child while I'm alive? Heck no. Don't ever do that. There's several reasons why we don't want to invite additional owners to our bank accounts or to our property. Number one, they now own that asset. They can do with that asset what they want. Number two, it exposes that asset to their liability. If they're in a cause of a car accident or if they get divorced, we've suddenly opened this situation up to these assets that they now partially own. And of course, there's another piece, and that is taxes. And so we see some real downside for tax reasons if we add somebody as a co-owner or if we give our assets during lifetime. So it's critical that we don't use joint tenancy and adding owners as a part of our estate plan purely for avoiding probate. There's a lot of risk and a lot of concern there. Now, beneficiary designations, I did mention that designation is a non-probate transfer. So there's an exchange of paperwork. So can you avoid probate by having beneficiaries on your bank accounts in your retirement account? Absolutely. Can you do that with property in Arizona? Yes, we have beneficiary deeds. Is that always appropriate? No. Sometimes we have beneficiaries that shouldn't get direct control and ownership. Beneficiary designations are not going to work when we have minor children or when we have children who maybe aren't good with managing money, or we've got other, complicated designations of what we want to happen to our estate. If I want my estate to go equally to my 10 nieces and nephews, I'm not going to do a beneficiary deed to say that they all own 1/10 of a house. That would be a nightmare. So the answer is yes, beneficiary designations in the right circumstances absolutely can help us avoid probate and can be a wonderful tool to do that. Now, beneficiary designations and POD, pay on death, or transfer on death are very similar. They're the same idea, but it's going to depend on the nature of the asset you're trying to pass and what terminology we use. So transfer on death versus pay on death, very good. And then the other way we avoid probate is fully funded trusts. So you were going to wonder how the trust got involved in this conversation, but we've learned a lot of different things about this so far. But just like I did with wills, I do want to be transparent about the 5 negatives of relying on beneficiary designations to avoid probate. So one thing is the backup plan. Sometimes our financial institution or our beneficiary deed might say, well, if this beneficiary dies, then here's what happens. But a lot of times that piece gets missed. So there's not really a great set of contingency planning on the beneficiary designations. I might say I want my house to go to my brother, and I might say I want my car and my bank account to go to my sister, and then I pass away. But the month before I passed away, my house got sold because I moved into a nursing home and my car got put into the junkyard because I wasn't driving anymore. And that's just destroyed my estate plan, right? So we have to understand that how beneficiary is tied to a certain type of asset. It's really hard to plan for contingencies, and sometimes those contingencies are outside of our control. So you can easily see how that also can undermine our estate plan. Sometimes, again, we want to say, well, I want everybody to be fair. I want everybody to get half and half, or everybody gets a third. Well, if we've named different beneficiaries on different assets, and there's a period of time during our life where we're not carefully monitoring that, very quickly the balance can come out. And so we want to make sure we're clear about what that looks like. There's also no protection for beneficiaries, so they pass directly to the beneficiary with no oversight. And that works great if you've got adult responsible beneficiaries who have no liability concerns, you're not worried about divorce or creditors, that kind of thing. But it's not always the case. It's not true in every situation. And it's also not suitable for anybody who's receiving government benefits. So if they're getting Social Security or Medicaid, we need to be really, really careful about how we do that. And again, it might create family conflict. You might sense a theme here. This family conflict idea is, hey, what are we inviting to the conversation, and how is that going to open doors to prevent or support family conflict? So when we think about trusts, we are thinking about a document that is an additional estate planning tool that we might want to put in place. And so what is a trust? A trust is like a will, in the sense that it's on paper, it's full of legal words, you're signing it, you're naming who's going to be in charge, where you want your assets to go, but it's different in many ways. And that's because instead of just rewriting and nominating those different roles, we're creating a whole new set of rules, and we're making sure that we get to understand and plan for all of those contingencies, plan for all those rules, and do so in a way that allows for this system of support and designation to be in place. And a trust is, at the end of the day, paper, but it's only worth the paper it's written. Because as you noticed down at the bottom and what I said on the slide before, we only avoid probate if it's properly funded. Now, sometimes people will say, well, funded, does that just mean I need to have $1 million? No. It's very much back to that first point I made. If we're going to go through the time, the cost, the process of being intentional about defining who we want to be in charge, all of our contingencies, defining what we want to happen at incapacity, what we happen when we pass away, how our beneficiaries should all be protected. We need to make sure that it doesn't just stay paper. We have to go back to our itinerary, not our itinerary, our inventory of assets and make sure that our ownership and beneficiaries are set to flow through or are in ownership of the trust. And so when I write my trusts, the Emily Taylor Trust, and I say I want my brother to be in charge, and I've got all these different people who are benefiting, my 10 nieces and nephews, let's say. Well, in order for those rules to follow, I need to make sure that I go back and I take my house and I deed my house from myself as a person to myself as trustee of my trust. Now my house is owned and funded in my trust, allowing my brother to step in seamlessly without probate to manage my house, to sell it so he can divvy everything up to all my nieces and nephews. I need to go back to my financial advisor, or I need to go look at my bank accounts. Is my trust the owner of the account, or is my trust the beneficiary? I look at my retirement, I look at my brokerage, I look at my vehicles. So again, you can start to see how this all works. And in some ways, trusts are us doing a lot of the heavy lifting and a lot of the work to make it easier for those who are going to succeed us in this role. And so, if one of our goals is to make it easy for the next people to come along and manage everything and to avoid probate and to protect our beneficiaries, then a trust is an awesome tool that allows us to do that. And then the process of making sure that that trust is funded over our lifetime means that when something happens, when we are incapacitated or we pass away, it's going to be much, much easier for the right team to step in, for them to not have to open probate, and for our beneficiaries to be protected and provided for in the way we want them. I gave negatives of wills and beneficiaries. I better do it for trust. It's only fair. So sometimes people think the upfront cost of a trust is a negative. That cost, of course, is you're going to pay a little bit more in legal fees because we're going to have to do more work. Oh, excuse me. Um, so we're going to have to do more work in legal planning. And so that means that the cost of setting up a trust is more, not only in dollars and cents, but also in time, right? Because we're going to be intentional. We're going to do some of this hard work. Requires ongoing maintenance. Now, that's a little bit of a myth as well. Some people worry that if I set up a trust, I'm going to have to pay the bank X number of dollars or the attorney all this money over the rest of my life. That's not necessarily true. But when we have a trust, we want to make sure the ongoing maintenance is that it stays funded. Because you might like a new interest rate at a savings, you might go open a new account, move some money over there. Well, you need to make sure that that account's opened in the right way, that we've got the right beneficiaries, or that it's owned by the trust. And so it must stay properly funded. It also doesn't automatically protect assets. A lot of people think that trusts equal asset protection. Some trusts do, but they are very complicated and very complex, and it usually is in exchange for giving up some rights. So most trusts in Arizona tend to be what we call revocable living trusts. Revocable meaning we can change it. 10 years from now, I might want to change who's in charge. 20 years from now, I might want to change my beneficiaries. It's revocable. It's also living. I've created it while I'm alive. And so most of the time, I'm going to be my own trustee as long as I can. So for those reasons, that type of trust doesn't provide this absolute protection from liability, divorce, and creditors for ourselves. Now, can we plan and protect our what we leave behind for our heirs? Yes, that's different because at that stage, once we've passed away, it's an irrevocable trust, and we're going to define the rules in a way that hopefully does that if it's necessary or appropriate. But for this reason and many others, trusts also get misunderstood or misused. And so it's not an uncommon occurrence that somebody will walk into the office and they'll say, Grandma died, here's her trust. I don't need to go to probate because she had a trust, right? And I'll say, well, tell me, what did Grandma have? A house, a car, a retirement account. Great. Now tell me, how do you know that's in the trust? And I get nervous when I start to flip through this big binder of paperwork because I don't care what the paperwork says in there. What I need to know is I need to go know what the deed to the house says is the owner. I need to go to the bank account and see who the beneficiary is. I need to go to the retirement account and see who the beneficiary is. So you can understand that even though trusts are wonderful tools that allow us to accomplish a lot of really important things, they're not magic. So I hope that's fair. Now, 5 benefits of using a trust. Again, if it's properly funded, then it avoids probate. It maintains privacy because, again, probate opens those doors to other people being able to learn about things. It provides control over asset distribution, both during incapacity and death. It can protect beneficiaries depending on how it's written. We're going to make sure that if we've got, again, children who are minors, children or beneficiaries who receive Social Security or Medicaid, or just people who maybe shouldn't be managing their own money, we can provide a lot of layers of protection for our loved ones in there. And it prepares for incapacity. So when we talked about the financial power of attorney, that's still going to be a critical tool, even if we have a will, or excuse me, even if we have a trust, but it's going to make sure that we look at them together because the financial power of attorney will govern those assets and those decisions that are still outside the trust. And our trust is going to govern the assets that are currently in the trust. So both tools are necessary for periods of incapacity. Now there's other types of trusts. I have a whole bunch of webinars on special needs trust just because that's a decent size part of my practice. There's minors trust if we've got young adults. There's testamentary trust that can be created at our death. There's irrevocable trust for all sorts of reasons, Medicaid, asset protection, other things. So the question of the hour is, will versus the trust. Do you need one? Do you need both? Which is it? And the answer is, it depends on your goals and concerns. So we go all the way back to that first thing we talked about. Do you want to avoid probate? Is that important to you? Some people don't care, and that's okay. But we just need to understand that. How complex is your family or financial situation, right? So if I have a woman in her 90s who wants to leave everything to her adult son who has no liability concerns, who is completely able to manage this, might we be able to use beneficiaries for everything? Absolutely. So how complex is it? Do you have minor children or loved ones with special needs? Again, that's going to escalate the desire to protect them and to have extra mechanics in place. Are you concerned about privacy? Again, sometimes we've got family members that we know are going to come out of the woodwork and start looking for things or will cause problems under any situation. And are you willing to do some of the work up front? So it's fair when somebody will say, I don't care, I'll be dead. That's fair. You can feel that way. But if that's not how you feel, if you want to make sure it's easy for everybody after you're gone, that it's as seamless as we can make it, then some of this upfront work is necessary to help. Now, one of the other big critical parts of your estate plan is the who. We've talked a lot about the different elements, and I've alluded to the fact that we're going to name healthcare agents, we're going to name financial agents, trustees, but we have to think about who are the right people for these jobs. And so that's a big part of our estate planning process, working together, is talking about who's on the bench, who's on the team. Do we need to involve professionals? We've got a library of professional interviews with Arizona fiduciaries, so you could start to look at, if I need to involve a licensed fiduciary or a trust company, who should I pick? How would they work? That kind of thing. Guardianship, if we have that, again, minor or incapacitated adults, who do we pick for a guardian? Different skill sets, right? I might have one brother who would be amazing at being a healthcare advocate for me. He's going to go in and he's going to know what I want. He's going to advocate for me. He's going to figure out what's going on. He'll pull the plug if I need him to. But he may not be the right person for finance. That might be a different person. It might be a professional. So how do we build a series of check and balances, a network of support? How do we use the people who we trust and rely on to be a part of the plan, and who goes where? And then, of course, we need contingencies. We always need to have a backup plan. So who am I planning for? Thinking through, again, brainstorming, who's going to be on my team? Who can I think of? Do I need to look at professionals? But in the end, one of the most important things is to think about what you're really trying to accomplish. Is there a legacy you want to leave behind? Do you want to be charitable? Do you want to support organizations that have been meaningful during your life? Do you want to make sure your kids are set up for the long term? Do you want to just have peace of mind that your healthcare decisions have been communicated? And how do we preserve the relationships we want to preserve? Because that's really important. So Question is, what do you need? And hopefully the answer you know by now is the right tools and the right team for you. And that's different for everybody. It's not one size fits all. And that's why it's important to have an advisor that you can feel comfortable sitting down with, sharing your goals, concerns, sharing the options that are available, and working together to put those tools in place. And then to inform your team what that looks like so that everybody's prepared. So with that, I hope that was a good introduction to estate planning. I see one extra question I haven't answered yet, but if you're here live, please feel free to go ahead and type that into the chat. But the question is, does a husband and wife need a separate trust or can it be a joint trust? That's a great question. So when we're married, Arizona is what we call a community property state. So a lot of times, if we don't have a prenup or a premarital agreement, there's an idea of these assets we own, are they community property? Meaning, do we both have equal ownership or are they separate property? Did we inherit it? Did we bring it to the marriage? Did we receive it as a gift? So generally, if our estate is primarily community property, it's really common in Arizona to have a joint trust. Occasionally, we'll have a joint trust between a married couple to address the issues and what we're going to do with our community property, but maybe one of the spouses inherited a lot of money that they've kept separate, and they might have a separate trust to set up a separate set of rules there. But again, the short answer is most of the time married couples have a joint trust, but it's not uncommon also to maybe need a separate trust for a different reason. But that's one of the things that you're going to work with your attorney to really understand how that works. What is community property? What is separate property? And it depends a lot on the answers there. I am not seeing a lot of questions. Oh, here comes one more. If you prepare a will or a trust in Arizona but move to Wyoming or another state, what do you need to do? So anytime we think about these documents and these plans, we have to understand that these laws are still pretty state specific. But with that, most documents are going to say, I want this document to be portable. I want it to I want it to work and be recognized in the other states. So the answer to this question that I tell most of my clients, because people do move, that's fair. And the answer is they should work. However, just like I described the mental health care power of attorney being somewhat unique to Arizona, the state you move to might have a unique rule that I don't even know about because I don't practice there. So I think it's always a good idea that if you have an estate plan prepared by somebody in another state, that when you're in your new state, you get it reviewed and you might need to make a few updates. But it should work, especially in emergency or if you're traveling or that type of thing, or snowbirding, those kind of things. But it's just generally something we want to think about having in place. And if you move to another state, making sure there's not something else. The other thing I'll caution is we've not talked about taxes. Thanks goodness that we could talk about that all week. But taxes from state to state vary, especially in the estate tax context. So in Arizona, we don't have a state estate tax. We follow the federal law. But some states have their own set of tax rules related to estates. And you need to understand if the state you're moving to has that. And so that's why it's so critical to have an advisor, somebody who's on your team in that new state. And I think I've alluded to it, but perhaps I haven't said it. Estate planning is not one and done. It is not, we do this one time and we leave it on the shelf until we die and we forget about it, even if we don't have a trust. It's something that's living. It's something that's changing with you because your assets are changing, your team is changing, your life is changing every day. And so whether you move out of state or you stay in Arizona for the rest of your life, it's important and critical that we look at it. Just like we look at our prescriptions. We go see our doctor for a physical. We go file tax returns every year. We meet with our financial advisor a couple times a year. An estate plan should be a part of that review process, taking it off the shelf, looking at it, talking to the people we've nominated in these different roles, making sure they understand how your life is changing. So hopefully that answered the question. But the short answer is you need to have it reviewed to make sure that the laws of the new state you're in recognize what you've got in place. Okay, one more question. Well, you can keep asking, keep them coming if you'd like. If a trust was created years ago while we were married, how could I get a copy of the trust since we are no longer married? I do not know which law firm created the trust. So that's Complicated answer. So first of all, probably by nature of the divorce, the trust is no longer in force because divorce changes some of the rules. And so I would guess that the trust was probably terminated at the time you got divorced because your assets got divided and your assets got moved out of the trust. So while it is helpful to maybe try to find a copy of it, you really can't unless you can figure out who set it up. So there's different ways based on property and things, but more critically is you need a new plan, whether that's a will or a trust or what have you. But the divorce created a whole separate set of assets because ownership changed, and divorce legally um, changes beneficiary designations, ownership, all sorts of things. So divorce is an awesome opportunity to do a refresh on everything. And probably as part of the trust planning you did when you were married, you also put healthcare directives and financial directives, and I would guess you put your spouse on there in that primary position. So we want to start clean, look at everything, update it. And so it's a common part of the divorce process is to update your estate plan when the divorce is final so that we can clarify what your legal name is, how you own your assets, and then coming up with your own personal plan that doesn't include your former spouse. So I'm not sure if that's the answer you wanted to hear, but it's the answer. But I don't know that a trust copy is as critical if we understand that it doesn't work in that way. So questions keep coming. This is great. So if you are the executor of a will, but you are also a sole beneficiary of a few accounts, can you divide the accounts per the will, or are there unintended consequences? Um, Once you own an asset, because perhaps, I'm going to reframe this question into an example, right? So the question is, I set up accounts. I named my brother as beneficiary on three of them, and I signed a will that said I wanted everything to go to my 10 nieces and nephews. My brother has now received, I've passed away. He has ownership of these three accounts, but is asking, I know you intended for those to go to the nieces and nephew. What can I do? The unintended consequences, my brother owns those assets now. So my brother needs to be careful that if he is making distributions according to the will, he's gifting those assets. And so there's a whole set of laws related to what we're allowed to do there. So it's not to say he can't do it. It's not to say you can't do it in this scenario, but you want to be understanding that if legally that asset is now yours, we understand the tax consequences of giving it to somebody else and making sure that everything's consistent. So, there are ways to kind of fix that, but a lot of times there are a ton of unintended consequences, like you alluded to. So that probably makes sense. So, okay. Well, with that, unless two more questions kind of roll in, I just want to say thank you. I've appreciated our conversation and I think this has been great. So, I hope that if you have or need anything, you'll feel comfortable asking us. You're welcome to schedule a consultation through our website. And if you need anything, please let us know. And if you need a connection somewhere else, we understand that that might be important. So, with that, I'll say thank you and enjoy the rest of your day and keep working on this project because I think it's important.